Excuse me, we'll call this meeting of the Board of Funeral Directors and Embalmers to order. It is 10:14 on Tuesday, December 14th. We'll begin with the roll call. Ms. Bohannon.
Fred Berry.
Here.
Anthony Harris.
Here.
Tanya Haynes.
Here.
Clark McKinney.
Here.
Scotty Porsche.
Here.
Charles Rom.
Here.
Robert Shackelford.
Here.
Mr. President, all board members are here and accounted for.
Thank you, Ms. Bohannon. The Chair will entertain a motion to adopt the agenda as presented or to amend it as required.
So move.
All right. We have a motion by Mr. Harris. Oh, I'm sorry. Who was that by? I'm sorry. Mr. McKinney. And do we have a second?
I'll second.
A second by Mr. Harris. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. The next item of business will be to review and approve the board meeting minutes for our October 20th board meeting or to amend them as necessary.
Move that we approve.
A motion by Mr. Berry to approve the minutes as presented.
Second.
Second by Mr. Rom. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Our legal report will be the next item on the agenda. We have Mr. Anthony Glandorf, our Chief Counsel from the Regulatory Boards Division, with us today, as well as Mr. Troy Bryant, Associate General Counsel of the Regulatory Boards Division. So, gentlemen, we'll turn the floor over to you.
The first complaint is number 037-041. Complainant is an attorney on behalf of the sister of the deceased. Complainant alleges unprofessional conduct, specifically that the respondent, through an associate of theirs, has lost the deceased body and remains/cremated remains. Complainant took the statement of the deceased roommate who had interacted with the associate of the respondent on behalf of the deceased's family. The roommate stated that he paid and received a receipt from the associate and that the last time he saw the body, it was brought into the church. The associate responsible soon stopped all communications with the roommate and the family regarding the whereabouts of the body or the deceased remains or cremated remains. The respondent has not responded to the complaint. This complaint was sent for an investigation. The investigator spoke with the owners of the respondent establishment. The owners indicated that the associate had made all the funeral and financial arrangements with the family of the deceased. One of the owners stated that following the service and transfer to the crematory, he picked up the remains of the deceased and brought them back to the respondent establishment. The respondent contends that 2 or 3 days later, the associate returned to the establishment where he was given the ashes of the deceased. The respondent stated that they were under the assumption that the associate would deliver the remains to the family. Further, the respondent contends that neither the family of the deceased nor the associate ever paid any money to their establishment for services provided, stating that to date the associate still owes the respondent establishment $5,050. Finally, respondent stated that they have had no further communication with either the associate or the family of the deceased. The department spoke to complainant on December 9th, 2021 and confirmed that the family, the funeral home, and the client of complainant still do not have the remains. Complainant has not received any communication from the associate regarding the remains. And for recommendation, we'd like to open a discussion for what the board believes. What penalty plus cost of investigation does the board feel is necessary to issue to respondent based on the fact that the remains have not been provided to the family?
Open the floor for questions and discussion.
It looks like there wasn't a chain of custody used throughout the process, and I was wondering about the associate. Is the associate a full-time employee?
From my understanding, that is not the case. That the associate was essentially kind of for hire and not directly related to the respondent establishment, but the respondent establishment did work directly with the associate on this case.
The associate, we know for a fact that they were licensed, and
From my knowledge, the associate actually is practicing is not licensed as a funeral director. They was not revoked, but they surrendered their license and were practicing as a with supervision from the respondent establishment.
Not sure how his legal and his performance. He's acting as a funeral director when he made all arrangements and financial, which is pretty serious. And I'm just curious, does that not somehow generate a complaint against the associate as well?
There has been one lodged against the associate specifically as well. That one is not on this legal report, but there has been a complaint opened.
Statement is made that neither the family of the deceased nor the associate ever paid any money to the establishment for the services rendered. If the associate was acting in conjunction with or on behalf of the respondent, I'm concerned or confused about why they would be included in the individuals who might be responsible for payment.
I believe what I understand respondents replied to be is that they were under the belief that, I guess to put it in simpler terms, that the associate would be the middleman to the family and that the family would directly pay the associate and the associate would essentially settle up with the respondent establishment later. According to the establishment, that never happened and the associate took essentially both cuts.
Associate was not interviewed in the investigation process.
If I could interject, no, the associate will not speak with our investigator. They're currently not licensed. I believe at the time that this took place, they were licensed. That this complaint was filed, I believe, just a few months ago, but it had it was over a previous period of time, over I believe close to a year earlier, and so at the time that this happened, the associate licensed and rendered their license, but this was a follow-up complaint that was submitted to us on behalf of the attorney for the sister of the deceased, saying we still do not have the cremains, and so this was against the funeral establishment because we've already had a complaint against this associate funeral director that's been presented to this board.
So still to date, they do not have cremated remains, correct?
That's correct. That's correct.
So if we pass out a penalty here, is it against the establishment and the associate? Can we do 2 lines, or is it just the establishment?
This would be just against the establishment. I believe we've already, the board has already, I believe we've already had a complaint against the respondent on this matter. Excuse me, on the associate on this matter. Where
This all seems very familiar.
yes,
And this is not this particular remains was not included in a previous complaint against a couple of establishments, was it? Or is this a separate case? It's a separate human remains that we're dealing with.
it's actually.
And did they have and does the establishment have a paper trail where this associate picked up the cremains, or are they just saying, "Hey, we give them to him," and thought he was going to give them to the family?
I think what we have is where they were picked up by the associate from the crematory. So we knew that happened. But the establishment was kind of what I would say hands off on this transaction. and so had assumed that the cremains had actually been transferred to the family, but that did not happen. And so, but I believe that we've already, I believe we've already established a complaint against the associate. What I can do is I can check on that and come right back to down to the meeting. If y'all just give me
Just, I don't know. I mean, we don't. I'm just going off of memory here. I just want to be sure that this particular human remains wasn't included in a previous complaint against a couple of establishments beforehand.
Yes, I understand what we had
few
issues
months ago.
Yes, we had issues I think last year, whatnot, where there was several remains that had not been transported where
Yes.
they need to be transported, and what we received was certification from the funeral establishment saying that yes, this is what has happened to them.
Okay.
So yeah, I understand your question to that.
Feel like this is a completely
I think
a new person.
I think it is, but let me if you all want to either continue on this or move on to the next one, I'll go upstairs and double check, and I'll come back down to the board if y'all.
Roommate of the decedent stated that he did pay, at least for some portion of the services, and received a receipt from the associate. Was that receipt furnished as a part of the investigation?
No, sir, it was not. No receipt was provided. At this time, logic, I suppose, would suggest, based on what the respondent has said, is that they are with the associate. And unfortunately, since he will not speak to our investigators, that information kind of lies with him and with him only, and no one's been able to get that information from them. Speaking with the complainant on or last week, they said that they have attempted to procure that information from him on numerous occasions and never received any reply.
We don't know where the cremains are. We just know that the last person we know that had those cremains was a respondent. And so this complaint was actually lodged by an attorney on behalf of the sister of the deceased. And what's not in here is that attorney has actually filed a lawsuit against the associate funeral director. So this is actually in federal court to dispose of the actual issue. So the issue before the commission isn't to attempt to enforce the movement of the cremains. I think that's going to be done through the civil court system on there. But I'm actually going to go check. Mr. McKinney, I'm going to go double check because I think the board's already issued a authorized civil penalty against this associate for this matter. But I'm going to go check and I'll be right back down.
And also, I was looking at their past history. The very last looks like the very last consent order they signed was pertaining to this same thing.
Yes.
It looks like that was this. Looks like that was this year.
Mr. Glandorf, while you check, we might move on to complaint number 2, and then we can come back to this complaint when we have more information.
Complaint number 2 is 2021049621. Complainant/purported wife of the deceased submitted a complaint against respondent funeral establishment alleging unprofessional conduct for refusing to provide a death certificate, despite complainant's claims of being next of kin. Complainant states that originally the deceased mother was identified as next of kin, but after presenting a certified marriage certificate to respondent, and after calling the Tennessee Department of Vital Records to confirm its authenticity, respondent allowed complainant to sign the cremation form. However, complainant contends that respondent now refuses to supply a copy of the death certificate or provide the deceased ashes to her. Respondent replied stating the paperwork from the medical center listed the deceased mother as the next of kin. After being provided with complainant's marriage certificate, respondent allowed her to select the desired services and sign the necessary paperwork. However, on the day of the viewing, the deceased mother and the deceased ex-wife provided documentation showing that the ex-wife was still married to the deceased at the time of complainant's marriage. Specifically, that the ex-wife's divorce was granted 7 months after the marriage to complainant had occurred. Respondent ultimately made the decision to acknowledge the deceased mother as the next of kin and refused to provide the complainant, in this case, a copy of the death certificate per the wishes of the deceased mother. We would recommend closure for determination by a court of competent jurisdiction.
Motion to accept that recommendation.
Second.
We have a motion by Mr. Rahm to accept council's recommendation and a second by Mr. Berry. Do we have any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Complaint number 3.
Complaint number 3 is complaint number 2021-052661. This is a companion complaint to the complaint above. The complainant in this case is the mother of the deceased from the previous complaint and alleges unprofessional conduct against respondent. First, complainant states that the respondent required proof of next of kin multiple times, specifically in the form of documentation to show that complainant from the previous complaint was not the deceased wife. Complainant states they told respondent numerous times to not allow the purported current wife to have any of the deceased ashes or his death certificate. Further, complainant purports that the death certificate she was provided is incorrect, as it lists the deceased as married to the purported wife. Respondent replied stating that they complied with complainant's wishes and did not provide the purported current wife with any of the cremains or the death certificate. Respondent contends that they informed complainant that they would need to provide more than just a statement to vital statistics as to the reason for the change in marital status. Respondent purports that they communicated this to complainant but never received any evidence they could send to vital statistics to justify a change in marital status. Respondent stated they have made a request for the death certificate to be corrected and provided documentation to show a request had been made. This case was sent for investigation. The inspector spoke first to complainant and obtained copies of the deceased marriage certificate and divorce documentation from his ex-wife. The date of marriage was dated December 16, 2000 to April 27, 2018. Complainant further stated that the respondent failed to place the deceased obituary in the paper. Next, the inspector met with respondent, who stated that he informed complainant that the death certificate would have to be amended to reflect the deceased single marital status. Respondent contends he told complainant that this could take some time to amend and that he would need documentation to have the certificate amended. Respondent admitted that complainant had paid to have an obituary run in the local paper, but stated that it was not run for a reason he could not explain. The investigator stated there was no evidence that complainant's money for the obituary had been refunded. The inspector received a copy of the purported current wife's marriage certificate, which listed the date of marriage as September 4th, 2017. We recommend that the next of kin issue be closed for determination by a court of competent jurisdiction. However, we would recommend a $500 civil penalty to be reduced to $250 if respondent shows proof of an issued refund to complainant at time of execution of the consent order regarding the obituary that was not run in the paper.
I move that we accept legal's recommendation.
Motion by Mr. Berry to accept council's recommendation.
Second.
We have a second by Mr. McKinney. Any other discussion?
Could we also, Fred, if you don't care, can we amend that to say to also show proof of the amended DC there so that it's a complete done thing?
Sure. We can amend it to state that as well.
Motion is amended to include proof that the death certificate has been amended as appropriate.
Backward. That's something to determine by the court, which may not be. It might.
Good point.
Maybe asking the funeral director to do something that his attorney would advise him against doing at this time because of all the confusion. And it might be that the court is the one that makes a determination that eventually determines how the death certificate reads. And that could be a longer period of time before it goes through the court system and does all that. If there's a suit filed and it does.
I think that's an excellent point. So let's go with the original recommendation to accept council's recommendation.
All right. So the amendment is removed from the motion, and we have the original motion as made by Mr. Berry and seconded by Mr. McKinney. Is there any further discussion? Not, all in favor say aye.
Aye.
Opposed? Motion carries. Item 4.
Number 4 are complaint numbers 2021-056-591 and 2021-067-661. These are two different complaints filed by two different people regarding the same circumstances. First, complainant, husband of the deceased, alleges unprofessional conduct on behalf of the respondent. Complainant states that on March 4th, 2021, the ashes of the deceased were collected. The complainant requested that the ashes be put in an urn provided by the family. On July 19th, 2021, the family opened the urn to discover two pieces of identification in the urn. One contained information that did not belong to the deceased. Complainant called respondent, who requested the disc number. Complainant states they were told that the provided disc number matched the deceased information. The second complainant is the daughter of the deceased, whose mother's information was found in the urn. The second complainant's complaint is virtually identical regarding the alleged unprofessional conduct of the respondent, additionally alleging that respondent failed to ship them their mother's belongings. Respondent replied stating that on the date of cremation, February 23, 2021, they placed the deceased ashes inside a temporary urn. Respondent contends that on March 2, 2021, they removed the deceased remains from the temporary urn and placed them in the urn provided by the family. However, there were cremation labels for other deceased persons placed on the table where the transfer occurred. Respondent contends that the urn complainant received contained only the information tag of another decedent and maintains that no cremains were mixed in the urn. This case was sent for investigation. Respondent stated that after pulling the disc number in their records, they confirmed that the disc number had been assigned to the deceased and that they were, quote, 100% sure, end quote, that the ashes belonged to the deceased. Respondent further provided an explanation as to what they believed happened. When the staff transferred the ashes from the black plastic temporary container to the urn the family provided, an employee carried the urn and the metal round disc of the deceased to the cremation office, where the employee requested they get the identification device and information, quote, on the Hispanic lady, end quote. As respondent contends, the employee mistakenly picked up a file for another deceased Hispanic woman, the mother of the second complainant, and placed it in the cremation urn for the deceased in the first complaint. Thus, as respondent maintains, only the identification information was placed in the urn. Based on the above, a determination as to whether the cremains were correctly provided to the complainants cannot be determined by any process available to the board. The question as to whether the cremains provided to the families is that of the decedent created undue emotional stress upon the families that cannot be remedied. Likewise, respondent has acted unprofessionally in failing to maintain an accurate chain of custody regarding the cremains of the deceased, allowing such emotional stress to occur. We would recommend a $5,000 civil penalty plus the costs of investigation.
Motion to accept recommendation.
Second.
Motion by Mr. Tom to accept council's recommendation. And was the second by Mr. Harris. Any further discussion?
Just one question I guess I'd ask counsel about was, I guess the statement saying that the chain of custody wasn't followed. I'm trying to think through my mind. Is it possible the chain of custody was followed, but that you have this mistake of the wrong identification label being placed in? But in your definition, because of that means that the chain of custody was not followed?
I suppose at absolute best, the chain of custody was not followed as closely as it should have been, and that the chain of custody had a lapse large enough to create a significant doubt on behalf of the families. And while respondent is certain and adamant that these are correct, unfortunately, there's no way to determine that.
I can certainly understand how it can place doubt in the family's mind for sure, but it's just further emphasizes how important these chains of custody are and how costly a mistake can be. So, thanks.
Any other discussion or questions regarding this matter? If not, all in favor of council's recommendation, say aye.
Aye.
All opposed? Motion carries. Item 5.
Complaint number 2021-06-2291. Complainant intern at respondent establishment filed a civil suit against respondent alleging sexual harassment and assault. In response to the complaint, the respondent denies the complainant's allegations. In a communication with the department, complainant expressed they would like to have the complaint dismissed as the matter had been resolved. So we would request closure pending confirmation of closures from complainant's counsel.
Motion to approve.
Second.
Motion to approve by Mr. McKinney. I'm sorry, guys. These panels are interfering with my hearing. Stuff's bouncing off the walls here. And you had the second, so or Mr. Harris. All right. So motion by Mr. McKinney, second by Mr. Harris. Any further discussion? All in favor?
Aye.
All opposed? Motion carries. Item 6.
Complaint 6, complaint number 2021-06-5301. Complainant, sister of the deceased, purchased a pre-need funeral contract for her brother in 2013 while respondent establishment was under former management. Former management sold the establishment to current management in 2018. Complainant contends that both former and current management acknowledge that this contract has been paid in full, but neither will fulfill the contract. Complainant provided documentation to show that the contract had been paid in full and that the pre-need account was to be placed in irrevocable trust. Respondent replied through counsel stating that respondent had contracted to purchase from former management only the real property and business equipment. The contract stated all items were purchased as is and was not a contract for respondent to purchase former management's accounts, contracts, or debts. Respondent further states that current management, which opened a new and separate LLC from former management, has never been licensed as a pre-need seller and has never sold pre-need funeral contracts. The department searched all available records and found no documentation of an appointed trustee or trust account opened by former management. Based on the above, we would recommend closure. The purchaser of respondent establishment did not purchase any pre-need contracts from former management, and there is no record of an appointed trustee or an irrevocable trust account related to this contract. Complainant should seek civil or criminal remedies through a court of competent jurisdiction against the former establishment owner.
Question was, in the investigation, was there evidence of additional pre-need contracts, or I'm just wondering, with the previous owner, what is the situation with other prearranged contracts, and if the business that purchased them did not purchase those or take over that business, then what? I'm trying to think through my mind how that's regulated then.
So I believe what should have happened in this circumstance is the former management should have taken that money, put it in trust, assigned a trustee, and there should have been documentation of that. Based on the records we searched, it appeared that did not happen. It appeared that the former management did not follow the law as they were supposed to in that regard. That ordinarily, when a transfer and sale of this type occurs, that trustee would still be in charge and that money would still be in trust. But because the former manager did not follow the law as they were supposed to in that regard, it appears that there is no trustee linked to this pre-need.
I understand. So there could be other prearranged agreements, but because you could not find a trustee at all, so I understand. Thanks.
Has there been a complaint opened against the former manager?
To my knowledge, there has not been. From my recollection, he is, from looking through the databases and the records we had, he is no longer licensed as, a funeral director, embalmer, pre-need seller.
And so we couldn't ask for a response from that person?
I suppose, to be honest with you, I'm not certain. I suppose we could always ask for a response. Whether we would ultimately get one or not, I'm not sure, but If that's something the board's interested in, I can check into that.
Is there any history of how long the first establishment was in business?
I don't recall specifically, but if I recall, generally speaking, from the information that we had pulled, it had seemed like they had been in business for some time. But I do not recall specific dates. I apologize for that.
And no record of other complaints against the first owner?
Again, that would be something I would have to check specifically. I don't recall. Nothing jumped out to me specifically about that, but that could be a possibility. I could check on that.
I mean, my recommendation would be that we look into this a little bit further and check to see if there's any other complaints that we have in our records. It's just very concerning if the establishment is in business for some time and there's no record and we can't find a trustee, how many other people may be involved in this.
Where's the money?
Yeah.
Exactly.
That is
Sounds like in the former person's pocket.
Pocket, yeah.
Is that something that Mr. Gribble can be looked at, or?
I think whatever the board's decision is, I will let you know that the former management, the person's not licensed as a funeral director, so basically the board has no recourse. That's, I think, why legal is recommended that it be to a court of civil or criminal. Unfortunately, the person has lost the money. Fortunately, it's a small business that it probably is not very wide. It's a business doing 3 or 4 calls a year, 4 or 5 calls a year. So it's not one
Okay.
that's, it's probably done a lot of pre-need sales and may have been, of course, some of these complaints get filed with the funeral board relating to matters like this, and sometimes they get filed with burial services where they're determined by the commissioner's designee. I think I remember one other instance where the same former management was involved, and they weren't a pre-need sales agent. They weren't registered as a pre-need seller at the time, and not a funeral director, unlicensed owner operating it.
Robert, to clarify what you just said, the previous manager that now is no longer licensed, as I understand it, was that person also the owner of the establishment that sold the establishment, or was it a different owner?
I should have been, obviously the manager, whomever the manager was at the time the pre-need funeral contract was sold, was licensed, but the person who owned the establishment and who it appears was the recipient of the funds was not licensed and has never been licensed.
Are two distinct individuals, separate?
Yes, sir.
I also understand that now the manager, the previous manager that was serving, is no longer licensed. Is that what I understood?
I believe that is correct. Yes.
Okay.
And the current owners, managers had nothing to do with the situation with the money.
That is correct. They took over the business about 5 years after this contract was written, and essentially bought the business, just bought the building and bought the equipment that came with it.
I'll make a motion we accept legal's recommendation here, as I don't think we have any other recourse.
I'll second.
Motion by Mr. Harris to accept council's recommendation and a second by Mr. Rahm. Is there any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. We'll continue with item 7.
Complaint number 7, complaint number 2021-065441. This complaint was administratively opened following an inspection conducted on September 14th, 2021. The inspector issued a citation for the following violations. 1. Violation of Tennessee Code Annotated Section 625303 for engaging in funeral directing, embalming, or operation of a funeral establishment without being duly licensed. 2. Violation of Tennessee Code Annotated Section 625313 for operating a funeral establishment without a licensed funeral director managing or supervising the establishment. And 3. Violation of Rule 0660-6-03 for failing to submit a final application to the board for the change of ownership for this establishment. The rule requires this to be done within 75 days. The establishment ownership changed over 92 days ago as of the date of this inspection. Respondent replied on October 4th, 2021, stating that his employer had informed them that all the proper paperwork had been submitted. The department confirmed that the correct and necessary paperwork had been submitted by respondent, so we would recommend a letter of warning.
Move that we accept council's recommendation.
Second.
Motion by Mr. Berry and a second by Mr. McKinney to accept council's recommendation. Is there any further discussion? Not all in favor say aye.
Aye.
Opposed? Motion carries. Item 8.
Complaint number 2021-065921. Complainant, son of the deceased, stated that he had yet to receive the death certificate for the deceased. Complainant stated that the deceased passed away on September 7th, 2021, and that since the primary care physician would not sign the death certificate, the body had been at the funeral home for the past 16 days. Complainant expressed that without the proper paperwork, he could not file her life insurance or have her shipped to New Jersey to be buried with the rest of his family. Respondent replied stating that they had diligently been in contact with other physicians in order to have the death certificate certified. After learning that the primary care physician would not sign the death certificate, respondent made numerous calls to various offices in an attempt to get a doctor to certify the certificate. Respondent states that on September 24th, 2021, a medical examiner finally agreed to sign the certificate as pending. Respondent stated the certificate has been filed and complainant had picked those up and viewed the deceased before shipping the remains to New Jersey. The department spoke with the representative in the Vital Records and Statistics Division of the Department of Health and confirmed that they had received the death certificate. It appears that the respondent took reasonable steps to get the certificate certified in a timely manner, so we would recommend closure.
Motion to approve.
And a second by Mr. Rom to approve council's recommendation for closure. Any further discussion? Not all in favor say aye.
Aye.
Opposed? Motion carries. Item 9.
Complaint number 2021-066361. Complainant is an employee of the Vital Records and Statistics Division for the Department of Health. Complainant alleges that respondent has failed to timely file multiple death certificates into the VRISMQ. Specifically, complainant stated that the unfiled certificates date back to deaths that occurred on January 7, 2021, January 27, 2021, June 28, 2021, and August 26, 2021. Complainant stated that they have spoken to respondent on 5 separate occasions, and respondent has yet to complete the certificates. Respondent replied stating that all but one of the listed certificates have been filed. Respondent contends that the final one has yet to be certified because the doctor it was assigned to has refused to sign the certificate since they had not seen the patient in over a year. Respondent further contends that they have made attempts to find another doctor to certify the final certificate and that difficulties with the VRISM system has led to further delay. The department spoke with the complainant in the Vital Records section on December 9, 2021 to check on the status of the delayed certificates. The representative stated that the current oldest certificate goes back to October 8, 2021, and that only 2 certificates in the VRISMQ have not yet been assigned to doctors. The complainant noted that due to the significant improvement in respondents' VRISMQ, they were willing to have the complaint closed, and we would recommend a letter of warning.
What was their reason for the delay in the other death certificates?
They did not specifically address as to why that delay was so significant. Essentially, they said that the queue system sometimes would mess up and cause for delay, and things of that nature, but never specifically provided a reason as to why deaths from January had not been certified yet.
Being one that uses that system every day, yes, it does have its kinks, but I feel like that's not acceptable. Is there a reason why we would not do a fine there instead of a letter of warning?
The legal would certainly not be opposed to a fine in this regard. It was essentially we went with a letter of warning given the complainant's satisfaction with their respondent's progress. However, it was clear to legal that at the bare minimum, a letter of warning needed to at least somewhat just not allow the complaint to close so that this would deter future delays.
I have a tendency to agree with Harris. I think a letter of warning will not do what it needs to do. I think a monetary fine would be more of an attention getter, and not to pay from Harris, but I would recommend a $500 fine.
I'll second that motion.
Have a motion by Mr. Rahm for a $500 fine in this matter, and a second by Mr. Harris. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Item 10.
Complaint number 2021071291. Complainant, acquaintance of the deceased's wife, alleges that respondent failed to cremate the deceased in a timely manner. Specifically, complainant alleges that the deceased passed away on July 27, 2021, and respondent was unable to cremate the deceased until September. Complainant claims that the wife of the deceased still does not know the status of the cremation, and that respondent refused to provide complainant any information regarding the deceased or the cremation. Respondent replied stating that a permit could not be obtained right away because the deceased had not seen a physician on a regular basis. Respondent contends they obtained the permit on September 14, 2021, after writing the medical examiner's office, and cremation took place on September 16, 2021. Respondent maintains that the deceased wife is aware of the status of the cremation as she received the cremains on September 24, 2021. Finally, respondent stated that they did not provide information to complainant because she had not been listed as a family member by the wife of the deceased, and thus respondent was not permitted to speak to complainant regarding these matters. The office has attempted to contact the wife of the deceased and have not received any communication from her or from the deceased family. So we would recommend closure. Complainant is not related to the decedent. The decedent's family has not provided information in relation to this complaint and have not joined in or contributed to the complaint.
Recommend that we accept council's recommendation.
Second.
Motion by Mr. Berry and a second by Mr. McKinney to accept council's recommendation. Any further discussion?
One question there. Was there an explanation why the respondent waited 2 months to get help from the ME's office there?
As I understood respondent's reply, that they had, in that meantime, been seeking other ways to have the permit, to receive the permit, and that essentially that's how long it took them to finally get a lead that panned out to receive the permit.
Questions or further discussion? If not, all in favor say aye.
Aye.
Opposed? Motion carries. Mr. Glandorf has returned.
Thank you.
Getting worried about him.
Well, when you have to scroll through PDFs, it takes a while to have to actually, read through whatnot. But yes, so this matter was already presented to the board previously under previously numbered complaint for disposition, and so the board's already weighed in on that one, and we've already sent out a consent order for civil penalty against that respondent, which they haven't responded back to us. I don't think they'll. I don't expect that they would, and our likely course of action next is just to file a notice of hearing and charges against that respondent, and so that matter would come back to the board with everything else for a disposition at a later time. So far as this complaint, I don't think there's a need to open up a new additional complaint against the respondent. Against that associate funeral director on this one since it's already been disposed of with the board.
This is a complete different human remains on this establishment. Is that correct?
For this establishment, it has not come before you with this establishment for the missing remains. Correct.
Okay, so this is a new one.
Yes.
Okay.
Back to the point of discussion to determine what the board's wishes are regarding the disposition of this matter.
Having seen they just have appeared on this similar practice this year, I'd be in favor of making a recommendation, and somebody can override me if they want to, but at least a $5,000 penalty here.
Motion by Mr. Harris for a civil penalty of $5,000, and I would assume
I'll second that.
include
Cost of
Cost of the investment.
cost of the investigation.
Is that in addition to the 5,000?
yes.
Second by Mr. Rahm. Is there any further discussion? All in favor of the motion, say aye.
Aye.
Opposed? Motion carries. Item 11, I believe.
Complaint numbers 2021071661 and 2021071641. These complaints were administratively opened by the department following an order issued by the Mississippi State Board of Funeral Service against respondents embalmer and funeral director's license, respectively. The Mississippi Board, in their findings of fact, stated that respondent had been indicted in the Circuit Court of Grenada, Mississippi for conspiracy to commit a crime and 2 counts of insurance fraud. On August 15, 2019, respondent entered a plea of guilty to the felony crime of count 1, conspiracy to commit a crime. Further, in violation of a board rule, respondent failed to notify the board of his conviction. Respondent replied stating that they pled with the district attorney for the well-being of their family and states that he was a victim of unfair and unlawful prosecution. Respondent maintains that he is not guilty of crimes of moral turpitude or unprofessional conduct. Respondent also contends that he failed to notify the board because he was informed by the authorities that they would inform the board. Based on the above, a felony conviction of conspiracy to commit a crime is considered a crime of moral turpitude under Tennessee Code Annotated Section 62-5317. We would recommend a $2,000 civil penalty to be assessed as a $1,000 penalty against respondent's funeral director's license and a $1,000 penalty against respondent's embalmer's license, respectively.
That fine is a result of not notifying the State Board of Tennessee?
Yes, and so the recommendation tracks the Mississippi Board's penalties as well. I believe, in addition to that, they added a 1-year probationary period to begin once payment had been made. But the Mississippi Board itself did not revoke the license, so the penalty would be linked to failure to notify the board of that conviction as well as the felony count.
If he moves states, then you could elude the fact of the probation. I'm curious if he had have notified the state board, what would have been the decision of the board at that point as far as his license. So they're typical. If you received a request for reciprocating a license, and you were notified that a crime had been committed and a conviction, how would typically the state have dealt with that as far as issuing a license for Tennessee?
This person already had a license issued prior to this.
In Tennessee?
In Tennessee, yes. They were licensed in Mississippi, committed the offenses there.
Oh, state. Okay.
And then through some research of our department, we became aware of what had taken place there, and the department administratively opened these complaints against his Tennessee license as a funeral director and embalmer because the respondent did not report what happened in Mississippi to Tennessee.
If he had have reported it, would there have been any action?
Lane open for to deal with it.
It would have been based upon the felony and, of course, not just the felony itself, not for. And this one is completely just because of failing to report. Is that correct?
Counsel said
Or
for
both?
the felony and failing to report.
Okay, so it's
For both.
both.
Yes,
This is
sir.
for both. Okay. This is
Had he reported, it would just been for the
Okay.
the felony.
Okay. All right. I understand.
We have the right to do probation on his Tennessee license as well, or not?
Yeah, that would. We could do the probationary period to essentially track the Mississippi board as well.
Yeah, probation on a license isn't something that's recognized in the statute, so it's a thing that we would have to recognize. What is the probation for? Is it that if there's something else that happens in a period of time, then the board would move forward with a more harsher penalty or whatnot? So just to kind of explain that, because I'm not sure Mississippi may have that terminology in their license structure, but it's not here in Tennessee.
I'm just thinking that would give us grounds if something came up soon with the same individual.
Right, and so usually what would happen is that we would, if something else came up, we would remind the board of this past issue that we had, and they would be taken in consideration together. Yeah.
So are you saying probation would be good or not be good?
He would have to work. Well, we could do it. He would have to agree to it in a consent order. And an example language was we would say that he would agree to a probationary period of, let's just say 1 year, for example, of which if he was during that period, if he has to report any arrest to the board, and if he pleads guilty or is convicted of any other felony, then he would agree to automatic either suspension or revocation of his license.
If he didn't agree to that, what would be the recourse?
Yeah, so then if he wouldn't agree to that probationary period, then it would be incumbent upon us, if we couldn't agree to anything, we would have to have a formal hearing on the matter, and then at formal hearing the board could either issue civil penalties or suspension or revocation of the license.
Members of the board, I think under the current circumstances, this is a fairly hefty penalty for this individual. And as it's been duly stated by Mr. Glandorf, if something comes up with this individual again, then it would be brought back to us where we could issue a probation or a suspension of the individual's. I make recommendation that we accept council's recommendation and just see if this individual.
I'll second that.
Motion by Mr. Rahm to accept council's recommendation and a second by Mr. McKinney. Is there any further discussion or any other questions? Not all in favor, say aye.
Aye.
Opposed? Motion carries. Item 12.
Complaint number 2021071901. Complainant competitor submitted a complaint against respondent funeral establishment alleging delay of death certificate and invoices. Complainant contends they contacted respondent to do removal and embalming for the deceased on September 29, 2021. Following these services, the deceased was picked up the same day, and complainant provided respondent the necessary information to complete the Tennessee death certificate on September 30th, 2021. Complainant ordered 5 death certificates and asked for an invoice to be faxed to their funeral home. Complainant contends that they contacted respondent several times over the next 2 weeks regarding the death certificates and invoices. Finally, after receiving contact from the family requesting the death certificate, complainant contacted respondent on October 19th, 2021. Complainant contends that respondent stated the death certificates would not be mailed until payment had been received. This complainant again requested the invoice be faxed. The invoice was received that day. However, respondent cannot accept payment via credit card to expedite delivery of the death certificate, so complainant mailed a check. On October 26, 2021, complainant contacted respondent, who stated that the check had been deposited the week before and that they would mail the death certificates. Respondent replied stating that the invoice was faxed to complainant on the same day they requested the necessary vitals information, October 7, 2021, and faxed again on the same day when an employee of complainant requested the invoice. Respondent stated it is standard operating procedure that death certificates are not sent out until payment for services are made. Respondent faxed the invoice again on October 19, 2021 after request of complainant. On October 26th, following another call from complainant, respondent's employee informed complainant that they had just received his payment in the mail that morning and had entered it into their system. Per standard operating procedure, the certificates had already been placed in the mail upon receipt of payment and had already been mailed at the time of complainant's call. We would recommend a letter of warning.
We have verification that the complainant did receive those.
We do not. The complainant did not provide a rebuttal stating that they had not received it, but some language could be added pending confirmation that complainant received death certificates.
I move with legal's recommendation letter of warning, but to follow up just to make sure the complainant did receive those death certificates.
Motion carries to accept council's recommendation with the stipulation that we follow up and ensure that the complainant did indeed receive the death certificates. Do we have a second?
Second.
Second by Mr. Rahm. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Item 13.
Complaint number 2021071871. Complainant, daughter of the deceased, filed a complaint against respondent for allegedly mishandling the body of the deceased. Complainant originally sought to use the removal and services of respondent, but when told that they were not available for an appointment for the next 4 days, complainant sought the services of a different establishment. When complainant contacted the hospital to let them know of the change, the hospital informed complainant that the respondent had already picked up the deceased. Complainant purports that respondent refused to return the body until complainant paid the transportation costs. Respondent replied stating that when complainant agreed to their arrangement, an employee was sent to pick up the deceased. When respondent learned that complainant had decided to go with a different funeral service, respondent arranged for the new funeral home to pick up the deceased from their establishment and informed complainant that their fee for removal is $395. Respondent states that complainant paid this fee. Respondent likewise attached documentation from the hospital to show that the complainant gave verbal permission for respondent to pick up the deceased from the hospital. We would recommend closure.
Motion we accept legal's recommendation.
Motion by Mr. Harris to accept council's recommendation. Do we have a second?
Second.
Second by Mr. McKinney. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Next item on the agenda is the Executive Director's report. So, Mr. Gribble, we'll give you the floor.
Thank you, Mr. President. Good morning, board members. First, we're going to look at the financial data for fiscal year 2021, which would be from July 1, 2020 through June 30th of 2021. This information was provided to the board's executive director by the Assistant Commissioner's Office for Regulatory Boards of the Department on November 15 of this year, and for its use in compilation of this report. Beginning balance on July 1, 2020 was $1,269,374. Net revenue or earnings for July 1, 2020 through June 30th, 2021, $472,614, which makes the total funds available $1,741,988, and the total expenditures for July 1, 2020 through June 30th, 2021 is $540,797. which makes a reserve balance on July the 1st of 2021 of $1,201,191, with the exception of a separate line item for a core expense for fiscal year 2021. And as you're probably aware, the core expense is related to the licensing system, and each board or each commission was charged a certain part for that core expense for the year, and the department prefers that it be separate from any other item and specifically noted on their financial statement. So that core expense was $70,605 for the Board of Funeral Directors and Embalmers, which makes a reserve balance after the core expenses on July 1, 2021 of $1,130,586, which is in line with a 2 years reserve, and that's typically what most boards look at, because if you look at their expenditures, basically the expenditures were $611,000 for the year. So typically all boards try to have a 2-year reserve, which puts us right at that amount. To break it down further so you can see some comparisons, if you roll over to the next page, and I've highlighted some items there, and certainly I'll be glad to answer any questions, but I think the items I've highlighted is what I thought would be of particular interest to you. So if you go to the far right column, which is fiscal year 2021, then you can see where the total expenses were $540,797 plus that core expense of $70,605 you'll see down at the very bottom. And the licensing revenue for that period, the $438,689. Case and complaint revenue is $48,935. The regulatory fee is a fee that we pay to the Department of Finance and Administration based on the number of licensees that we have. That fee is $15,010. So it shows that we have a deficit of $68,000 for this fiscal year that closed June the 30th. And as you probably recall, every other year we have a deficit, and every other year we have a pretty good profit, for lack of a better word. So it's because all the licenses don't renew at the same, are not evenly distributed among the months of the year, then it causes for that. And you can look there at the 4 years to see how things compare as far as expenses.
You know how to, what is the, I noticed in years 18, 19 where there was a almost 150,000 deficit, and this past year was 68. How come there's so much difference?
If you, of course, to compare with this year that just closed, we would need to look at fiscal year 18 and 19, which the deficit was $149,140. So, Mr. McKinney, if you take the $68,183 plus the $70,000, then that brings it to $138,000, $139,000, somewhere, right, which is comparable or similar to the other. Back at the time then, the core expenses may have been included in the other expenses. And for some reason now, it's been decided that it's best to break those out and keep them separate.
Is there a motion required to accept this, or is this just for information?
For information, but at the end of my report,
Okay,
that
gotcha.
the motion then would be inclusive of this. While we're on this, does anyone have any other questions or any additional questions or comments? Or obviously, you saw that travel was down some to what it was has been in previous years, and that has to do obviously with the Zoom meetings and WebEx meetings. So, you know, meeting in person again, that will go back to its normal level. Legislative update. Representatives from the Tennessee Funeral Directors Association and their department met recently to discuss possible legislation the association may pursue when the General Assembly reconvenes on Tuesday, January 11, 2022. Our office has not received any notification from the Tennessee State Funeral Director and Morticians Association of legislation they intend to pursue. And as always, we extend an open invitation to the associations or any other individuals or interested parties to meet with their staff and other appropriate department individuals prior to introduction of legislation affecting, this board. Licensee reports the report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of October 16, 2021 through December 10, 2021. Closed establishments that are reported since the last board meeting be Patton Brothers Funeral Home, 1306 South Street here in Nashville. As far as disciplinary action, there's nothing to report for this meeting for disciplinary action on the disciplinary action report since the last board meeting. The complaint report for this meeting, there are 18 complaints have to deal with funeral directors and embalmers and 23 that have to do for establishments, which would be a total of 41 complaints that are open at the present time. That concludes my report, but if you have any questions, I'll be glad to answer those.
Motion to
Second.
Motion by Mr. Rahm to approve the Executive Director's report as presented, and a second by Mr. Harris. Any other questions for Mr. Gribble or any discussion?
One question, would that include, has there been any notification to burial services on any legislation?
Yes.
Okay.
From the Cemetery Association,
Yeah, okay.
we have an indication that they, to burial services, which is the commissioner-run program, that they intend to pursue some legislation. And also they have requested, and we've agreed to meet with them. It's probably not going to occur until another week or so. But Cemetery Association has notified burial services that they do intend to pursue legislation, and the department has agreed to meet with them to discuss that prior to introduction.
Further questions for Mr. Gribble? If not, we'll call for the question. And all in favor say aye.
Aye.
Opposed? Motion carries. Next item on the agenda would be applications for licensure. We do not have any individual applications to appear before the board today, but we do have an establishment application. And we will introduce Mr. Michael Alobry and Mr. Billy Orange, who are with Compassion Funeral and Cremation Services. You have their information as a part of your packet today. They will be located here in Nashville, Tennessee, assuming things go well today. So, gentlemen, we give you the floor and let you share with us what you would like to share at this time.
Morning, board. My name is Michael Alobry. I will be one of the owners. This is my co-worker currently, and my business partner, Billy Orange. We've known each other for 20 years now. This is all done. I remember I'm a native of Lebanon, Tennessee, and I remember at 8 years old, I would make my brother play funeral with Legos, so he can definitely attest to that. And fast forward to the summer of 1997, right before I was entering my senior year, I contacted Ligon and Bobo Funeral Home. Mr. Clark McKinney answered the telephone that morning, and I expressed to him my interest of wanting to be a funeral director. He provided me with the number to John A. Gupton College. As soon as I graduated high school, I was enrolled into John A. Gupton College just a few months after that. I'm a 1999 graduate of John A. Gupton. Been with Family Legacy or Mr. William Greger for almost 20 years in my career. As you know, they were acquired by Parklawn Corporation. Will be 2 years in March. So we are not opposed to the corporation or anything. We're just going a different route. We feel like we can provide a better service at a more affordable cost. So we're excited, and with the board's approval, we're going to continue to do what we've always done, take care of families like we have all these years. Really?
Very similar story to Michael. I've been in the funeral business for 20 plus years. Jim Brewer raised me in the. I was with. Legacy. To have a chance to serve families and do what I know best.
Brought a guest with you?
Stone Cold Steve Murphy.
Does the location of your establishment allow for independent outdoor signage?
As we were waiting on the board's approval before we got involved with, we got the logo designed. Of course, you've seen it on the that, but we are just waiting for that.
Closer to the mic.
Okay, sorry.
Is there a common sign out front, or does your sign go beside your door or
So the
above your door?
it could go on the door, it could go on the window, and it can go right above the door, a hanging sign. So we've got that in the works. We're just waiting for the approval.
That was the only question that I had.
You will not be doing pre-need, or maybe in the future?
Maybe in the future, we just want to get open, kind of get how things are working, and then we will address that later on as we get moving here.
I may have noticed that your location may lie within the floodplain.
But we're kind of, yeah.
Do you have any concerns about that or any
No,
issues
we
that
had
you're
checked
aware
on
of?
that. It had not flooded in several years. I mean, that is a possibility. So we'll, with the insurance, we'll make sure that's taken care of.
But Music City will be housing your deceased.
They will take care of all of cremations and embalmings of the deceased.
I noticed on the price list, and this, I haven't seen it before, but maybe it's on other Tennessee funeral establishment price list, but there's an expedited cremation within 48 hours. I was a little intrigued by that. With the increase in cremation, it's, at least in my area, it's very difficult sometimes to get a cremation within 48 hours. So I was wondering about that particular item on your price list.
Sure. When you have the paperwork, once everything's in place, then, when you're meeting with families, some families are in a hurry to get things done. Typically, we would have to coordinate that with Music City to see what their schedule's like. But they assured us that, once we have the paperwork in hand, they could expedite that for those families that are needing it quicker. I guess the normal turnaround, once you have your paperwork, where we're at currently, we have a crematory on site. So once we have the paperwork, we can turn it around. It really depends on the schedule, how busy you are, and, the caseload. So some folks, really want it quick. But, for the most part, that's just on there just in case of people. As you know, families can be somewhat demanding on their time frame. They don't really care about it. Definitely understand that.
I just want to be cautious of that commitment because it would be totally dependent upon Music City and their schedule.
We would communicate, promising, and definitely before.
I'll make a motion we approve this application.
Motion by Mr. McKinney to approve the application as presented. Do we have a second?
Second.
We have a second by Ms. Haynes and also by Mr. Harris. So, any further discussion? Any further questions for these gentlemen? Not all in favor of approving the application as presented, please say aye.
Aye.
Opposed? Motion carries. Gentlemen,
Appreciate it.
congratulations.
Appreciate it. Thank you.
We wish you well. Next item on the agenda is the election of board officers for 2022. The first office that we will discuss will be that of president.
I'd like to nominate Charles Rom for that position.
Second.
We have a motion by Mr. Harris and a second by Mr. McKinney to nominate Charles Rahm for the position of president.
Discussion,
Yes.
Mr. President. Just, I guess, put this as a thought. It just seems like the guidelines for how offices are determined and seeking office is not very clear. And so you have to be very careful about discussions and what is said outside the meeting. And this seems like that we ought to look into some type of written guidelines or something to follow where there's a method in the public meeting to determining who might have interest. And so I guess in our current board makeup, there's a situation where there's several of us rotating off at the same time. So if there's interest from multiple people of going through the chairs or serving as an officer, there's limitations there. And it just seems like that, maybe it's, before in October, or there's in the meeting, there's a discussion about who has interest in positions, so that gets out on the floor to everybody. Everybody has an opportunity to make their wishes known if they have a desire, and then to think through that. So I don't know how we would go about doing that, but it seems like that would be a very good and transparent way of how to determine officers for the next year. And nothing against Mr. Ron, does a fantastic job. But like in this situation, Mr. Ron served previously as a president. And so if there's any other interest in that position by the board members that's going to be rotating off at the same time, it's going to make it impossible for each one of those individuals to have an opportunity to serve. So that's why I think it would be good to have some type of process of and it wouldn't have to be. And again, I'd have to lean on Mr. Gribble or our legal counsel to recommend how that might be done. I don't know if any other boards do that any differently, but it just seems like that would be a more transparent method of electing officers. So just wanted to put that out there as food for thought.
Thank you, Mr. Berry. Any other comments related to Mr. Berry's point?
I guess just for our knowledge and to make sure, I guess I'd ask counsel on what your thoughts about that, and are you aware of any other boards and how they handle that to make that process as transparent as possible, giving that discussions typically have to happen within a meeting?
So this isn't the first board that would bring up a concern about electing officer positions on the board. You're correct that all discussions and votes of the board have to be open to the public, and that does include the officer appointed boards positions for the board, which I've often seen where there's a recommendation and someone nominates someone, and then they get a second for the nomination, and then they vote on them. Is generally how we see that happening, though I think there could be other methods where people volunteer. as a member, but the voting and the discussion does need to be in the public forum.
So if we did want to put some guidelines to that, would that need to be made as a motion at some point in the future and voted on if we wanted to bring more clarity to that?
So some of the boards I think have bylaws. There's no reason why you couldn't do bylaws on elected on positions within the board where, for instance, you could have it so that the sitting vice president would rotate to the president position next is how it would happen, and then the secretary would go into the vice president position. You could do it that way so that if somebody was elected into a position, there's already a progression as to where they would go on there, so that wouldn't have to be a separate voting each time. You all could create that via, I believe, the bylaws of the board is how it would happen.
That would be the mechanism.
That would be the mechanism, because the board has adopted Robert's Rules of Order as to how we do things, and Robert's Rules of Orders allow for bylaws. And if a lot of boards and commissions don't have bylaws specifically in their statutory scheme, but it's a natural. Generally, Robert's Rules allows for these assemblies and bodies to create its own bylaws. So if you wanted to create some document that showed a progression of how that would work, I think you could do that. But we would review it to ensure that it's transparent to the public, so that it would be, everyone would understand how that worked, and so that there's not what we'd consider to be a secret ballot of positions being nominated.
So if there were multiple individuals nominated, then there'd be some type of ballot process that.
Oh, if nominated, not via a ballot, but you'd have to vote. You would have to vote in the open on it.
But that's what I meant. But so it'd be okay. I understand.
Right. If there was two people nominated for the same position, we've had boards ask, could they poll everyone where you don't have to individually give your take on it. Probably usually under the guise of trying to avoid animosity or contention on it, but that's not allowed. The vote has to be known to the public. Each member's vote has to be known to.
Thanks for your clarification.
Thank you, Mr. Berry. I appreciate your comments, and I think you do raise a valid point. There are probably many cycles where that does not become an issue, but in this particular cycle, it is. And I think you are correct in your statement that there should be a better process going forward that allows people who do have an interest in the positions to express that in a timely fashion so that the board can make an informed decision. So I appreciate your comments. Are there any other thoughts or comments that need to be expressed before we call for the question on the motion that's on the floor now? Motion is made by Mr. Harris to elect Charles Rahm as the incoming president for the 2022 year, and the motion was seconded by Mr. McKinney. If there is no further discussion, all in favor, please say aye.
Aye.
All opposed? Motion carries. Congratulations, Mr. Rahm. Next office to be filled is that of Vice President. So we'll entertain nominations for the office of Vice President.
I will place Mr. Harris's name for Vice President.
Kenny has placed the name of Mr. Harris as Vice President. Is there a second?
Second.
Second by Mr. Rahm. Is there any other discussion? Not. All in favor of the motion as presented, please say aye.
Aye.
Opposed? Motion carries. Congratulations, Mr. Harris. The next office to be appointed is that of the Continuing Education Liaison, so we'll entertain nominations for that role.
Motion for Fred Berry.
We have a motion that Fred Berry be named as the Continuing Education Liaison for 2022. Do we have a second?
Second.
Second by Mr. McKinney. Any further discussion? If not, all in favor of the motion, please say aye.
Aye.
Opposed? Motion carries. Congratulations, Mr. Berry. Under new business, we have some information there that Mr. Gribble will explain to us in further detail, and you have some information, I think, in your packet as well.
Regarding CE Broker, CE Broker will soon become the official CE tracking system for this board, and the purpose for it is to a better way to efficiently and effectively, the licensees can get their CE reported, the CE providers can report it, and it be there whenever they get ready to renew their license. There's no, obviously the question is, what does it cost the licensee? And there is no cost to that. Now, if they want a concierge account, then there is a cost to it. But within the basic free system, you have the access to your course history and CE compliance status. And it's a list of all the courses which have been reported thus far and indicates whether or not you have satisfied your renewal requirements. And it came to us in a meeting about a year and a half, 2 years ago, where the department was meeting with CE Broker. And this CE Broker has a support center. It's based in Jacksonville, Florida, staffed with experts who will be thoroughly trained in the rules and regulations of the board, be open to the licensees from 8 a.m. to 8 p.m. Eastern Time, Monday through Friday, and they can also contact them through email or live chat. But many other boards use CE Broker for this system. And another thing it does, it will reduce, typically what happens now, when a course is approved, Ms. Bohannon's much more aware of this and how the process works than I am. But once the course is approved, she sends a letter to the provider notifying them of the course being approved and how many hours of CE it's approved for. Then when they have that course or have someone that completes the course, then they send documentation back to her that notifies them this is a list of the people who completed. Well, then one of our administrative assistants has to go in and manually key all that in. So you can imagine how much time that is. And with this system, they'll have a system that speaks with their system and will automatically populate that to the licensee's file. And it will be much more, as with businesses, we look for better, efficient, and effective ways to operate, and this is one of them. The Tennessee Real Estate Commission was the first one that was to be in line to get this. And so the people here in the department, I kiddingly told them, okay, I want us to be second. We can't be first, let's be second. And it turns out that they've done a lot of work and weeded out a lot of the problems, but they have a few things going on right now that they may not, we actually may be the first board to go to it. So it doesn't matter to me whether we're first or second or third, but I think it's a good thing, and I think it'll be good for our licensees. And I wanted to make you aware of it. It's probably not going to take place until February or March. I would hope that it would happen before what's normally the larger renewal cycle, which is June the 30th of even numbered years, so June 30th of 2022. I hope it's in place and happens before then. And they've assured us to give us good support through the process, and communications have been good with them. They've been very timely in their communications. Ms. Bohannon will be doing a lot of testing and training to, and vetting the system to make sure it's working correctly. And do you want to speak to it? I wanted to make you aware of it. I don't think it's anything we need a motion for or anything like that. It's just one of those things that we want the board to be aware of it and answer your questions before we announce it to the public.
Questions regarding CE Broker and the role that they will play in helping to track continuing education requirements for our licensees? Well, thank you for the information, Mr. Gribble. We also have some reaccreditations that have been issued, and would you like to speak to those, Mr. Gribble, as well?
I was hoping maybe Mr. Spann would be here today where the board could personally recognize him. But the American Board of Funeral Service Education is the accrediting agency for mortuary colleges. And we receive a report from the American Board of Funeral Service Education on a routine basis. And the Committee on Accreditation Actions for October of 2021, the committee took this action regarding the funeral service and mortuary science education programs when this committee was meeting here in Nashville on October 14th and 15th of 2021. And John A. Gupton College in Nashville was reaccredited for a period of 7 years, and I've highlighted there the things that I thought were important for you to see. They were reaccredited with no stipulations. They were recognized, among other things, for strong financial support, ease of use and accessibility of information on the website and in print, facilities and learning environment that fosters student success and organization, structure, administration, teamwork, and other things. So it's, from what I see in the observance of mortuary colleges, that would be as good a report as you could hope to get. And any other good mortuary colleges, and I'm not a graduate of John A. Gupton, but I think it's a very, very good college based upon what the American Board of Funeral Service Education has done in the reaccreditation. And just had a discussion with the assistant commissioner, and he felt like it was something that the board need to be made aware of. And then you can look through there and see, how other colleges, what their situation is, and gives you appreciation to know where different colleges are. And since it's something just happens once every 7 years, I wanted to make you aware of it.
Thank you. Third item under new business is the availability of a delegate grant to the annual meeting of the International Conference of Funeral Service Examining Boards, and you have some information in your packet regarding that as well. Mr. Gribble, would you like to address that?
It's an opportunity that the conference is making available. It's open to any board member or any staff person. It's the date of the annual convention is February 23 and 24. It's in Houston, Texas. And the conference is making a delegate grant of one available to each board in their jurisdiction. And the purpose of this information for you today is for the board to make a selection, if you wish, to determine who would be attending that. When I sent this out to the board members, Mr. Berry responded back to me and told me that he would have some interest in that. I did not receive responses from anyone else. And also need to work with administration. I guess whatever the board would do today in making a selection would be subject to approval by administration, because we all have travel policies that we must adhere to. All being including boards as well.
I personally feel like Perry would be an excellent.
Do you still have an interest in attending the conference?
Yes, if I can be of support to Mr. Gribble and help in any way, I'm open to that.
Need a motion to that effect? All right, so we'll entertain a motion that.
I'll move.
All right, we have a motion by Mr. Rahm that Mr. Berry be appointed as the delegate to the conference in Houston on February the 23rd and 24th. Do we have a second?
I'll second.
Second by Mr. Harris. Any further discussion? Not all in favor, please say aye.
Aye.
Opposed? Motion carries.
Barry, I'll forward you some information. I think the deadline to apply is January 14. The conference had indicated they would prefer that the application to be there by January the 10th. So it would be my suggestion you go ahead and do the application to the conference, and then we'll work internally to get departmental approval.
Gribble, a question for you. Going back to Mr. Berry's point earlier, does this board have a bylaws committee standing bylaws committee that has been appointed?
Does not that I'm aware of. I was going to look at the statute, and I couldn't pull up LexisNexis while y'all were talking about that. I know Mr. Glandolf referred to that some boards have a secretary. This board has typically never elected a secretary. It's been a president and a vice president. So I know the statute calls for a president, and I don't know whether it's just through bylaws that they elect the vice president or not. You have some other sources there that you can look at to see what, but to answer your question, Mr. President, to my knowledge, the board has no standing committees.
I was not aware of any, but I just wanted to be certain that.
And the committee is appointed at various times for various reasons, but there are no standing committees that I'm aware of.
And didn't years ago the vice president's position was called the secretary? It's been some years ago. Probably before your
before
tenure.
My time, yeah. Because I think I remember seeing on licenses hanging on the wall that you'd see somebody's. But then I think it was just president and secretary. I don't remember seeing a vice president when they would. That was back when all board members signed the licenses.
Yes.
And so I think at that point it was president and secretary, I think.
Mr. President, I'd like to make a motion that whether it's a committee or that we look into, and it seems like the mechanism is bylaws. It doesn't need to be very complicated, but I just think there needs to be something in writing and something as new board members come on that everyone's aware of how that works. So I'd make a motion that either we appoint a committee to work with legal and Mr. Gribble, or I'm not sure how that should work out, but maybe they can make a recommendation as to how we would go about that. But I guess I would assume that maybe there is a committee that would work on that and bring that back to the board.
I think that would make sense, and that was where I was headed with that. So your motion is then that the board form a bylaws committee to explore the process of nominating and electing officers for future terms.
Yes, sir.
This would be a short-term committee.
Yes.
Yeah.
I'll second that.
Second by Mr. Rahm. Is there any other discussion?
I guess we'd have to figure out the mechanism of who wanted to serve on that committee.
All in favor of the motion as stated, please say aye.
Aye.
Any opposed? Motion carries. I'm first going to ask for volunteers to serve on that committee. Are there any individuals who would like to volunteer to serve on our newly formed bylaws committee?
Happy to.
I would say.
All right. So was that Mr. Harris said I'll be happy to, and Fred, you said that you would. Is there anyone else that would like to serve on that bylaws committee? All right, Ms. Haynes would like to serve. I think probably a three-person committee would not be too unwieldy. So unless there's someone else that would like to jump on board, I think that would be a good start. So we will name those three individuals to this newly formed bylaws committee. And then the committee may, in and of yourselves, determine how to best approach this subject in consultation with Mr. Gribble and our legal department. You may bring your findings back to the board then when you're ready to do so. Very good. Well, today will be my final meeting. It's hard to believe that 4 years have already passed. Of course, in the midst of COVID, there have been some extraordinary things that have happened and some unique and creative ways that we've had to come together as a board that we probably never foresaw just a few years ago. But this has been a great honor and privilege for me to have been able to serve on this board. In some ways, it is, for lack of a better term, a legacy position for me. My father served on this board, as did your dad, Fred, and I know others probably have as well. So I very much appreciate the ability and the honor to serve on this board, and I appreciate the honor of serving as your president for this past year. This has been a great learning experience for me, and it's just been a great opportunity to renew some old friendships that I've had for a long time. Graduated from John A. Gupton College with Charlie, and have known Fred Berry as long, I guess, I've known anybody, and knew his dad well, known Clark for many, many years, and some of you I've just had the privilege to meet while I came on the board, and it's been a great experience and a great opportunity, and I appreciate all of your service to this state and to the people of this state, the consumers of this state, and to our profession. And I look forward to hearing great things from you as the board moves forward. So thank you for the opportunity. It's been a privilege and a pleasure to serve with each one of you.
Thank you for a
Excellent
job well done.
No, you won't see me next month. I think my appointment is waiting in the wings. We can't announce who that is at this point because there's still some things that have to be finalized, but I believe that all but a few details have been completed, and my appointment is waiting in the wings and will be here in January. So you'll find out who it is when they walk through the door in January. Is there any further business that needs to be brought before the board today?
Motion to adjourn.
Well, we have a motion by
Second.
Mr. Rom to adjourn and a second. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries.